I'm Ben Meiselas from the MeidasTouch Network. In a unanimous decision, the South Carolina Supreme Court has denied Mark Meadows' emergency application to try to block his testimony before the Fulton County Special Grand Jury, which is conducting a criminal investigation into election interference in Georgia in the 2020 election. The Fulton County Special Grand Jury is impaneled under the supervision of presiding Judge Robert McBurney, and it was called by the Fulton County District Attorney Fani Willis. Now, Mark Meadows has been appealing and trying to block his testimony before the Fulton County Special Grand Jury and before the January 6th committee, and he's been losing at each and every turn. Let me just remind you of what took place before the South Carolina Supreme Court issued its order today, where they found that Mark Meadows' motion to try to block his testimony was not just without merit, but they state was manifestly without merit, is the exact language used by the South Carolina Supreme Court. So you rewind a little bit. The Fulton County District Attorney Fani Willis subpoenaed Mark Meadows through a process that it's a two-step process you have to engage in when you're bringing someone who lives outside of a state for a subpoena to testify within the state. Each of the various states abide by what's called a Uniform Act to secure attendance of a witness from without a state in a criminal proceeding. It's a two-step process. So first, the Fulton County District Attorney files an application with the presiding judge who's overseeing the criminal grand jury, the special grand jury. That's Judge Robert McBurney, who made a finding a few months back that Mark Meadows was indeed a material witness in connection with the criminal investigation taking place in Fulton County. The next step is that the Fulton County District Attorney then has to file an application or a motion in the state where the witness resides, because the court in that state is the court that physically has the jurisdiction over the witness to actually compel that witness's testimony. And generally, the other states will always abide by a finding in another state that a particular witness is a material witness. So here, the Fulton County District Attorney's Office then filed the certification of material witness by Judge Robert McBurney before Judge Edward Miller, who's a circuit court judge in the Court of Common Pleas, 13th Judicial Circuit in South Carolina. That's where Mark Meadows apparently lives, although Mark Meadows may live in North Carolina and Washington, D.C. I don't know. He's registered to vote in so many different locations, but that is a whole nother story. But Judge Edward Miller made the finding that indeed Mark Meadows was a material witness. Mark Meadows tried to make a number of arguments before the Judge Edward Miller there in South Carolina. Mark Meadows argued, well, technically what's taking place in Fulton County is not a criminal proceeding. It is like a civil investigation. Lots of other individuals involved or connected with the January 6th insurrection have tried to make that argument regarding the special grand jury in Fulton County, but it's always been a criminal grand jury, a special criminal grand jury investigating election interference that is going to be making recommendations to criminally indict people. And Judge Robert McBurney, the Superior Court judge in Fulton County, has made it very clear that it's a criminal function. It's part of a criminal investigation that the Fulton County Special Grand Jury is engaged in. Mark Meadows' other argument was that he has these executive privilege claims that were pending in Washington, D.C. federal court there before Judge Carl Nichols, although Mark Meadows lost that federal case. And in any event, that has nothing to do with the claims before the Fulton County Special Grand Jury, even though Meadows lost. So it didn't matter either way, and it was kind of just a frivolous objection. Even a more frivolous objection that Mark Meadows tried to raise is that because the subpoena to go before the special grand jury was dated at an earlier date because the parties were trying to coordinate Mark Meadows' schedule, that therefore it mooted the entire subpoena, and that was a completely frivolous objection as well. So Judge Edward Miller on November 7th ordered that Mark Meadows would be compelled to testify before the Fulton County Special Grand Jury that is investigating the 2020 election crimes in Georgia. So the next step that Mark Meadows did, he kind of bypassed the Court of Appeals, the kind of intermediary Court of Appeals. So the circuit court in South Carolina is like their superior court. It's their trial court, their lower court. The next step would normally be appealing to like an intermediary appeals court. But Mark Meadows sought certification before the South Carolina Supreme Court, asserting the same arguments that he made before Judge Edward Miller, which was rejected before the lower court in South Carolina. And he added one additional argument there, which I thought was particularly specious and highly offensive. And that's Mark Meadows argued that his privacy rights would be infringed if he was compelled to go before the special grand jury. He said under the South Carolina Constitution and just under the United States Constitution, somehow his privacy rights would be violated because he argued that the special grand jury would be preparing a report in Fulton County and his name would be mentioned in that report, and that would violate his rights to privacy under the United States Constitution, but more specifically, the South Carolina Constitution. I did another video on that where I was like, how dare Mark Meadows make that argument? At the same time, Mark Meadows and Republicans have taken away a woman's right to privacy and a woman's right to freedom over their body, saying that they don't have privacy rights. He's making an argument that there's a privacy right for his name not to be mentioned in a grand jury report where he was integrally involved in the January 6th insurrection. I said that was beyond absurd. And evidently the South Carolina Supreme Court agreed. I was a little nervous when the South Carolina Supreme Court expedited these proceedings. I was like, I haven't really studied in detail the inner workings of the South Carolina Supreme Court, but I was like, I don't know. It's not a great sign that they've like put this on a fast track. But the good news is that, you know, justice has prevailed here, even in a Supreme Court that may view some issues differently than how I view them. When it comes to Mark Meadows, we both agree that his motion was manifestly without merit. So let's just pull up the order right here from the South Carolina Supreme Court. It says per curiam, P-E-R-C-U-R-I-A-M. That means it's a unanimous decision of the South Carolina Supreme Court. And it says the following: pursuant to the Uniform Act to secure the attendance of a witness from without a state in a criminal proceeding, a South Carolina Circuit Court ordered appellant, that's Mark Meadows, and the Circuit Court is Judge Edward Miller's court, to appear and testify on November 30th, 2022, before a special purpose grand jury impaneled in Fulton County, Georgia, to investigate allegations of possible attempts to disrupt the lawful administration of the November 2020 elections in Georgia. Appellant, that's Mark Meadows, appealed the order of the Circuit Court and filed a motion to certify the appeal to this court, the Supreme Court, arguing the merits of his appeal in his motion. We granted the motion to certify the appeal, and because of the exigent circumstances involved in the matter, requested a response from the state of Georgia to the arguments presented by appellant in the motion to certify, to respond to Meadows' specious arguments in his motion to certify before the South Carolina Supreme Court. Now, we have reviewed, the South Carolina Supreme Court has reviewed, we have reviewed the arguments raised by appellant Mark Meadows and find them to be manifestly without merit. Manifestly without merit. Accordingly, we affirm the order of the Circuit Court, Judge Edward Miller. They're saying we agree with what the lower court, Edward Miller, did, pursuant to the whatever rule it is of the South Carolina Code. Affirmed, then it's all of the judges' names in the per curiam or unanimous decision. So what this means is Mark Meadows is compelled to testify before the Fulton County Special Grand Jury on November 30th. So he will be testifying right away. He was not able to weasel out of it like he tried to do. And we will see what he does. Is he going to invoke his Fifth Amendment rights against self-incrimination? Is he going to try to avoid the testimony and try to duck and dodge and be held in contempt? Is he going to lie? Is he going to throw Trump under the bus? We will see. We will keep you posted here on the MeidasTouch Network, but that's the procedure. Mark Meadows has tried to avoid this like the plague, but his time is up. He's been compelled to testify. Testimony before the Fulton County Special Grand Jury, November 30th, 2022. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button right now. We are on our way to 1 million subscribers thanks to your support. And in addition, please check out our Patreon site at patreon.com/MeidasTouch. That's patreon.com/MeidasTouch. Consider becoming a patron. We're not funded by any outside investors at all, so we rely 100% on you and your support. So please, if you can, become a patron. If not, no worries about it. But consider it wherever you are in the world. Let's grow this thing together. I'm Ben Meiselas from the MeidasTouch Network. Until next time.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs. It wasn't rigged, you're just a loser. At store.meidastouch.com. That's store.meidastouch.com.